With me now, our friend and white-collar crime expert, Seth Berenzweig. Let's bring in one of our favorite legal analysts, Seth Berenzweig.
He's been recognized in honorary lists of legal elite and super lawyer in the Washington, D.C. region, and he regularly handles government contracts and labor and employment law. He joins us from our Washington bureau. Mr. Berenzweig, welcome.
The most important asset that a trial witness has is his or her credibility. Not only are they going to get him ready for direct examination, but they have to get him ready, and they did, for a blistering cross-examination. The questions that are going to be coming over will be questions that will be similar to what shareholders will be asking. If this leak allegedly happened, where were you at that time? Where were the internal corporate controls? If the CEO is asleep at the wheel, then the car's going to crash. So he has to be aware of exactly what's going to be happening, who's asking the question, and what the minefields are out there as this trial progresses. You can't have 6 plaintiffs accurately representing 1.5 million employees. That was just fundamentally, in the court's opinion, incorrect. In a sharply divided vote, which was essentially 5-4, it was ruled that it couldn't even be remanded back down. Yeah. So if these individuals are going to move forward, they have to do so individually. There's nothing legal about insider trading. There's nothing legal or appropriate about having these secret investor networks that are not subject to any disclosure at all. Look, if we're going to protect the American investor, we need some very basic registration and transparency requirements so that we can take care of this. If you don't have transparency, you don't have a free market, you have a fixed market. And once we have transparency in place, people can make their own investment decisions and they're not going to lose their fortune. The bottom line on this is that Solyndra was basically a ticking time bomb that the agency failed to hear. Around the time that the loan was provided, an audit by Pricewaterhouse had indicated that about $550 million had been run in the negative for the prior 5 years of the company's operations. So it really didn't perform the right due diligence. It doubled down later when it provided this loan restructuring, and legally what that means is that when it's in the bankruptcy court, it basically has to stand towards the back of the line. So they really went from bad to worse. Now the legal claim is compromised, and it really makes it much harder for the taxpayers to get their money back.
Thank you, Seth. We appreciate it.
Thank you so much for your insight.
Always a pleasure to have you on. Thanks so much for your perspective. We appreciate it.